in the name of personal injury law.
In 2019, there were major changes made to the Michigan no-fault auto insurance law. These changes passed without any public hearings and through a rushed legislative process. Some say the changes were needed to bring down the cost of auto insurance, while others have found many aspects of these changes to be controversial and troublesome. Today, we're going to talk about a lawsuit pending in the Ingham County Circuit Court that seeks to challenge the constitutionality and enforceability of various parts of the no-fault changes. This lawsuit is being handled by the Sinas Law Firm, and we have with us today Stephen Sinas of the Sinas Law Firm and his special guest to talk about it. So hello, Steve. Welcome back to the show. Before we begin, could you please introduce our special guest today?
Yeah, it's great to be here. It's great to have my guest here today with us. I have my highly respected colleague, Lauren Kissel, who's an attorney at our law firm, and she has been working extensively on this lawsuit that we're going to talk about today. And I'm also very pleased to have members of the Andary family. We have Dr. Michael Andary and his daughters, Michelle Andary and Caroline Andary, and they are plaintiffs in our lawsuit. And Lauren's going to explain that to you. I just had a couple quick comments. Our firm was heavily involved in the no-fault insurance reform debate. We advocated for certain changes. The changes that were implemented were not the ones that we thought were good for Michigan. And we looked at these changes, and there's a time where you feel as an attorney and as in a law firm, you need to step up and take a stand against bad legislation and legislation that has concerning issues. And so we feel that we're doing that in this lawsuit here, and Lauren's going to explain to you what it's all about. So please take it away, Lauren.
Thanks, Steve. So as Steve and Lisa both mentioned, our law firm has filed a lawsuit challenging two specific provisions of the new no-fault law. It's currently pending in the Ingham County Circuit Court, and there are three plaintiffs in the lawsuit. The first plaintiff is the Andary family, who is here with us today. And then we also have the Eisenhower Center, which is a neurological rehabilitation center in Ann Arbor, and Philip Kruger, who is a person who was severely injured in a motor vehicle accident in 1990 and is currently a patient at the Eisenhower Center. This lawsuit essentially challenges two aspects of the new no-fault law. The first aspect is the 56-hour per week cap on in-home family provided attendant care. And we call it in-home family provided attendant care just to kind of simplify it, but really it's a 56-hour per week cap on any attendant care provided by people that the injured person knew prior to their injuries. And the second provision that our law firm is challenging is the 55% fee schedule that applies to services that are not compensable under the Medicare fee schedule. So in this regard, our plaintiff, the Eisenhower Center, is severely affected by that because centers such as Eisenhower, who provide neurological rehabilitation services, often are not compensable by Medicare. The main argument of our lawsuit is that the retroactive application of these two provisions to individuals who were injured prior to the date that the new law went into effect is unconstitutional. This is because these sorts of provisions, the rights of these individuals vested at the time of their motor vehicle accidents, and now the government is attempting to go in and change these, how these people can receive their benefits and what benefits these people can receive. The second thrust of our lawsuit is challenging the future application of the in-home family provided attendant care and 55% fee schedule provisions based on equal protection and due process grounds. As I mentioned before, the lawsuit is currently pending in the Ingham County Circuit Court, and we are awaiting a decision from Judge Stokes as to how the lawsuit is going to proceed.
So we have, like you said, the Andary families here today, and I really wanted to hear from them about how these limitations on attendant care are really going to affect your family and what concerns you have about those new limitations.
So right now, my wife Ellen was the person who was injured, and so we have been lucky enough to have a fairly large family and circle of friends and nieces and nephews and my siblings who've all pitched in and have been able to give virtually all of her care since she came home about 4.5, 5 years ago. And so we have been able to give her what I would argue as a physician who takes care of catastrophically injured patients, the best home care that she can get. And it's been all with family or close friends. And so from our point of view, we've been doing this for a long time. Why it's in the state's best interest to kick us out and have strangers come in and take care of her, we think that it's not going to be so good. So you guys want to comment on how this affects Ellen?
Yeah, you go for it. Yeah, I think it has been really great for our mom who, has always really respected her own privacy and being with her family and, really respects the family relationship and being with her kids most of the time. And we also love having that bond with our mom. And as challenging as it's been for our mom's recovery, it's been really challenging for us as well. So I think being able to see firsthand our mom's rehab and her recovery, it's been helpful for us to recover as well.
Yeah, our mom has a traumatic brain injury. She doesn't learn new people's names. So if we're not able to care for her, strangers coming into the house, new strangers all the time, she's not going to learn any of their names. They're not going to understand what she's saying half the time. If we thought strangers, and if research backed the fact that strangers take better care of catastrophically injured people, we would have done that 6 years ago. But the fact of the matter is we take better care of our mom, and she's more comfortable with us.
And if I may add, this rule that was passed by the legislature was passed in the name of trying to limit alleged fraud that was going on with people claiming care they're providing to family members. And the insurance industry was saying that there's too much fraud. So we now have to impose a rule that says that families like the Andarys, who suffer the most severe type of brain injury, who provide dedicated care, now can't be compensated, and now it must bring strangers into their home because we had a fraud issue. And this is an example, I think, where the legislature could have combated the issue of fraud in a much different way than taking that right away from the Andary family. And to make matters worse, the fact that they take the right away when it was already established under a private contract between the Andarys and their insurance company makes it all the more egregious. And that's the real rallying cry of our lawsuit here.
Can I just ask, what does 56 hours mean to your family? What is that? How does that work into your lives?
It's ridiculous. I mean, it is irrational and makes no medical sense as a physician.
Egregious.
We've had this. I mean, we bought this. And so why is it in the state's best interest to kick my family out and make Ellen be taken care of by strangers? It makes no logical medical sense. I'm a physician. It makes no emotional sense to our family. It makes no emotional sense to Ellen. And we bought something else. So I don't understand why the state found that to be important. And why not 57 hours? I mean,
And we can't guarantee we're going to win, but what they're saying is the real reason why we're behind this case.
Yeah. Well, thank you all so much for joining us today. This has been really helpful, and especially meeting the Andary family. We really appreciate you joining us. Thank you.
Thanks for having us.
Thank you.
In the Name of Personal Injury Law is brought to you by the Sinas Law Firm.